Jai Hind everyone. I am Dr. Akash from the Department of Applied Science and Humanities at AKGEC Engineering College, Ghaziabad, and we'll be having a discussion on a topic relating to the subject of Constitution of India, Law and Engineering. Subject code is KNC 501601. The topic of today's lecture is the High Court and Subordinate Courts in India, and I would like to have an insight into the structure of the High Court, its power, its autonomy, and will discuss highlight on some subordinate courts in India. The following are the major contents. So I will be going through the following contents: the introduction, the High Courts in India, Constitution and composition of High Courts. I'll also go into some details regarding the jurisdiction of the High Court. The High Court autonomy will also be discussed to an extent. Qualification and tenure of High Court judges. It's an important concept, one of the important one. Procedure for removal of judges. Transfer of a judge from one High Court to another under Article 222. Appointment of acting Chief Justice, Article 223, and subordinate courts in India. All these will be discussed at length. First of all, let us have some introduction about the topic. We are aware of the role of India's highest court called the Supreme Court. Just below the Supreme Court, there are High Courts, which are highest court of law in states. The High Court are part of Indian judiciary and function under the supervision, guidance, and control of the Supreme Court. As we all know that the Supreme Court is one of the apex court and looking into all the kinds of relating to all the aspects relating to judiciary in our country. Then we have the second stage, which is known as the High Court. As the highest court in the state, a High Court supervises and subordinates court in the state. Now, which court in the state? The subordinate courts in the state, which are next to the High Court. The High Courts are mainly court of appeal. These courts hear appeals from numerous subordinate courts working at district level. The system of appointment of judges, their qualifications, and the working of subordinate courts is under the direct control and supervision of the High Court of the state concerned. In our discussion today, we'll try to look into some aspects of the state High Courts and have an idea of subordinate courts, including the district and the session courts. So we'll just start with the lecture. High Courts in India. There shall be a High Court in each state under Article 214, but the Parliament has the power to establish a common High Court for two or more states under Article 213. The High Court stands at the head of the judiciary in the state. It provides the separate High Courts for separate state, but according to 7th Constitutional Amendment Act, the same High Court can be the court for more than one state. Now, it is important to understand that as the Constitution provides separate High Courts for separate states, but according to 7th Constitutional Amendment Act, the same High Court can be the court for more than one state. Let's see this under some examples. At present, we have 25 High Courts in country, 6 of these having control over more than one state or union territory. Delhi has a High Court of its own among the union territory. The state of Punjab and Haryana have a common High Court in Chandigarh. Also, the northeastern states like Assam, Mizoram, Nagaland, Arunachal Pradesh share the same High Court in Guwahati. Calcutta High Court is the oldest High Court in the country, which was established in 1862. So with this, we have the basic idea of what the structure of high courts is in India. Every high court shall consist of a chief justice and such other judges as the President of India may from time to time appoint. Besides, the President has the power to appoint additional judges for a temporary period which not exceeding 2 years for the clearance of areas of work in a high court. Next, an acting judge when a permanent judge of a high court other than the Chief Justice is temporarily absent or unable to perform his duties or is appointed to act temporarily as Chief Justice. The acting judge holds office until the permanent judge resumes his office. But neither an additional nor an acting judge can hold office beyond the age of 62 years. Every judge of a high court shall be appointed by the President. In making the appointment, the President shall consult the Chief Justice of India, the Governor of the state, and also the Chief Justice of that High Court in the matter of appointment of a judge other than the Chief Justice. Now, this slide slightly look into the aspect concerning with the appointment of a judge in a High Court and highlights on the aspect on the activity or the power of the President of India. The Constitution and composition of High Courts. The Constitution of India provides a High Court for each state, but the 7th Amendment Act 1956 authorized the Parliament to establish a common High Court for 2 or more states, as we have discussed earlier. In every High Court, there is a Chief Justice and many other judges whose number is defined by the President of India. The Article 217 deals with the appointment of judges and the state that every judge of High Court shall be appointed by the President by warrant under his hand and seal after the consultation with the Chief Justice of India, the Governor of the state, and in case of appointment of a judge other than the Chief Justice of High Court, and shall hold office in case of an additional or acting judge as provided in the article, and in any other case until he attains the age of 62 years. Now, this is another aspect which is looking us into having a glimpse of the structure and or we can say the composition of the High Court. Jurisdiction of High Court. The jurisdiction of High Court will be studied under the following major 8 points. The jurisdiction of High Court can be classified under the following heads: the original jurisdiction, the writ jurisdiction, the appellate jurisdiction, the power of superintendence, control over subordinate courts, court of record, judicial review, and finally the administrative power. Now, with the help of these, we will be able to have an insight into the working of the High Court at state level. The original jurisdiction, the point 1, it means that applicant can directly go to High Court and not by means of appeal. This power is used in following matters: dispute arising out of relating to members of Parliament and State Legislative Assembly, disputes relating to marriage, law, admiralty, divorce, contempt of court, etc., matters relating to the enforcement of fundamental rights. Supreme Court also has this power. Cases transferred from other court to itself, which involves a question of law. The High Court of Calcutta, Bombay, Madras have originally jurisdiction in criminal civil cases arising within these cities. An exclusive right enjoyed by these High Court is that they are entitled to hear civil cases which involve property worth rupees 20,000, over 20,000. Regarding fundamental rights, these courts are empowered to issue writ in order to enforce the fundamental rights. With respect to other cases, all high courts have original jurisdiction in cases that are related to will, divorce, contempt of court, and admiralty. Election petitions can be heard by the High Court also. So with this, we have an insight about the original jurisdiction of the High Court at state level. The writ jurisdiction under Article 226 states that High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within those territories, directions, order or writ. Appellate jurisdiction, the third power. It is said that the High Court is the primary court of appeal. That is, it has the power to hear the appeals against the judgment of subordinate courts, which we will be discussing in the later part of our lecture, within its territory. This power can be classified into two categories: the civil jurisdiction and finally the criminal jurisdiction. As far as the civil cases and its jurisdiction is concerned, it includes to the order and judgment of the district courts, additional district courts, and other subordinate courts. As far as the criminal cases are concerned, its jurisdiction includes judgments relating to sessions courts and additional session courts. These cases should be involving imprisonment for more than 7 years, confirmation of any death sentence awarded by session court before execution. In civil cases, the appellate jurisdiction, the discussion is continue now. In civil cases, an appeal can be made to High Court against a district court's decision. An appeal can also be made from the subordinate court directly if the dispute involves a value higher than 5,000 rupee on a question of fact or law. In criminal cases, it extends to cases decided by session and additional session judges. If the sessions judges has awarded an imprisonment for 7 or more years, if the session judge has awarded capital punishment, the jurisdiction of the High Court extends to all cases under the state or federal laws. In constitutional cases, if the High Court certifies that a case involves a substantial question of law, can also be heard. The power of superintendence. The High Court has this power over all courts and tribunals except those dealing with the armed forces functioning in the state. Hence, in the exercise of this power, it may call for return from such courts, may issue general rules and prescribe forms for regulating and practice and proceeding of such courts, prescribe the forms in which books and accounts are being kept by the officers of any court, settle fee payable to the shrift clerks, officers and legal practitioners. The Constitution, the point here to be understood or noted, the Constitution does not place any restriction on this power of the superintendents over the subordinate courts. It is not only by means of appeal by the person, it can be suo motu. It is of the nature of the revision as it verifies the earlier judgments. In this regard, it is considered as a special function, or as the Supreme Court has no similar power vis-a-vis the High Court. The control over subordinate courts. This is an extension of the above supervisory and appellate jurisdiction. It states that the High Court can be can withdraw a case pending before any subordinate court, if it involves the substantial question of law. The case can be disposed of itself or solve the question of law and return back to the same court. In the second case, the opinion tendered by the High Court would be binding on the subordinate court, and it also deals with matter pertaining to posting, promotion, grant of leave, transfer and discipline of the members therein. In this regard, it appoints officers and servants to be made by Chief Justice or such other judge of High Court as Chief Justice may direct. Court of record. It involves recording of judgments, proceedings and act of High Courts to be recorded for perpetual memory. The High Court are also court of record like the Supreme Court. The record of judgment of a High Court can be used by subordinate courts for deciding cases. All High Courts have the power to punish all cases of contempt by person or institution. The important point here is to notice in this regard that the record function, the maintenance of record by the High Court ultimately paved the way for future judgment, which are also known as the judicial precedents. These precedents in future are the guidelines on the basis of which the future cases are decided by different courts relating to the nature of the cases. Judicial review. This power of High Court includes the power to examine the constitutionality of legislative and executive orders of both central and the state government. Now, important point here is there has to be one important institution that may interpret whether the policies, whether the rules, whether the regulations being brought up by the state or the central government are in conformity with the various fundamental rights or the fundamental duties or directive principle of state policy. So we require one institution or one mechanism by which we can interpret whether these policies are in conformity with the constitutional bindings which are required to be followed and maintained in order to manage the different affairs connected with the public or directly with the public, or as far as the national environment is concerned, environment relating to the political, the judicial, the intellectual. It is to be noted that the word judicial review is nowhere mentioned in our constitution, but the Article 13 and 226 explicitly provide High Court with this power. Now, this is an important point. Administrative power of the High Court. The High Court superintends and controls all the subordinate courts. The High Court can ask for details of proceeding from subordinate courts. The High Court can issue rules regarding the working of subordinate courts, and the High Court can transfer any case from one court to another and can transfer the case to itself and decide the same. The High Court can inquire into the record or other connected document of any subordinate court. The High Court can appoint its administration staff and determine their salaries, allowance, and the conditions of service. Now, these administrative power are to an extent giving us an insight into to what extent the power can be exercised by the High Court as far as the administrative affairs are concerned, in line with the ensuring a proper functioning of the judicial environment at the state level or judicial activities at the state level. The High Court autonomy. The independence of the High Court can be corroborated by the points given below. Now, these different points are highlight the autonomy of the High Court in relation to different aspects. As far as the first point is concerned, the appointment of judges. The appointment of judges of the High Court lies within the judiciary itself, and is not connected to the legislature or executive. Now, this point is highlighting the sole important power, the sole power of the High Court judges. Tenure of the judges. The High Court judges enjoy security of tenure till the age of retirement, which is 65 years, and a High Court cannot be removed except by an address of the President. Point number 3, salaries and allowances. The High Court judges enjoy good salary, perks and allowances, and these cannot be changed to their disadvantage except in case of a financial emergency. If it arises in the state or at the central level, then the salary can be curtailed by this in a systematic way. The expenses of the High Court are charged on the consolidated fund of the state, which is not subject to vote in the state legislature. Now, this is the sole economic power they will be enjoying, except in case of financial emergency if it arises at the state or the national level. The powers. The Parliament and the state legislature cannot cut the powers and jurisdiction of the High Court as granted by the Constitution. Another monopoly to an extent, enjoying as far as the powers are concerned to be enjoyed. Conduct of judges. Unless a motion of impeachment has been moved, the conduct of the High Court judge cannot be discussed in the Parliament. Now, important aspect that since no judge can be removed, and it can be removed on the basis of some background, which we will be discussing in the later part of our lecture today. So, therefore, the conduct of judges cannot be discussed in the Parliament. The retirement. After the retirement, the High Court judge cannot hold any office of emoluments under the Government of India or that of a state. There is an exception to this clause. However, when with the consent of the Chief Justice of India, retired judges can be nominated to a temporary office, and in a situation of emergencies, they can be appointed to perform some of the judicial duties or administrative duties when called upon by the institutions. Now, look into the qualification and tenure of a High Court judge. In order to be appointed as a judge of a High Court, the person concerned should possess the following qualifications. First of all, he or she should be a citizen of India, one of the basic requirements. Second one is, he or she should have held a judicial office at the district level or below for at least 10 years, or he or she should have been an advocate in one or more High Court for at least 10 years continuously without break. Once appointed, the High Court judge hold office till they attain the age of 62. Now it is 65. After the retirement, they may be appointed judges of the Supreme Court, or they may practice as advocates either in Supreme Court or in any high court other than the High Court in which they serve as judges. Procedure for the removal of judges. The Judges Inquiry Act governs the removal or impeachment of judges of High Court. In the two basic points: proved misbehavior, incapacity. He is removed by the President as per the removal order passed by each House of the Parliament by a special majority, that is a majority of the total membership of the House and a majority of not less than 2/3 of the members present and voting. A detailed procedure followed is as under. The initial removal motion to be signed by 100 members in Lok Sabha or by 50 members of Rajya Sabha and by presented to the Speaker, Chairman of the House. The Speaker has the option of either accepting or rejecting the motion. If it is accepted, a committee would be constituted to investigate the matter. The committee so constituted consists of Chief Justice or judges of Supreme Court, Chief Justice of High Court, and a distinguished jurist. If the committee ascertains the guilty of the judge, then a houses can take up the issue. If the motion is passed in each house of the parliament by a special majority, then it is later presented to the president for his assent. The president then passes order for removal of judge. The judge is considered removed from that day. In fact, no judge has been removed till now in our country. Transfer of a judge from one high court to another under Article 222. The Article 222 of the Constitution of India makes provision for the transfer of a judge, including the Chief Justice, from one high court to another high court. The initiation of the proposal for the transfer of a judge should be made by Chief Justice of India, whose opinion in this regard is determinative. Also, when a judge has been or is so transferred, he shall, during the period he serves after the commencement of the Constitution, act as a judge of the higher court, so shall be entitled to receive, in addition to his salary, such compensatory allowance as may be determined by the Parliament by law, and until so determined, such compensatory allowance as the President may by order fix. Later, in 1977, in K. Ashok Reddy case, ruled that there requires judicial review in case of arbitrary transfer of judges. Hence, as to the locus standi, only the judge who is transferred can challenge it, nobody else. Appointment of acting Chief Justice under Article 223 of our Constitution. When the office of Chief Justice of a High Court is vacant, or when any such Chief Justice, by reason of absence or otherwise, unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the President may appoint for the purposes. However, the appointments of a person other than the district judge to the judicial service of a state shall be made by the governor of the state in accordance with the rules made by him after consultation with the State Public Service Commission and with the High Court exercising jurisdiction in relation to such state. Subordinate courts in India. We'll go at the later portion of the lecture today. Subordinate courts in India. The state judiciary consists of a high court and a hierarchy of subordinate courts, also known as lower courts. The subordinate courts are also called because of their subordination to the state high court. They function below and under the high court at district and lower level. In each district of India, there are various types of subordinates or lower courts. They are civil court, criminal court, and revenue courts. The district court of India are the district courts of the state governments in India for every district or for one or more districts, together taking into account the number of cases, population distribution in district. Any administer justice in India at a district level. These courts, under the administrative control of High Court of the state to which the district concerned belongs, the decisions of the district courts are subject to the appellate jurisdiction of the High Court. Now, as far as the hierarchy goes, this is the Supreme Court. This is the High Court and these are the subordinate courts. We will just have a point over here. Okay. Next, now this table represents a flow chart concerning about the subordinate courts. Now, subordinate courts are basically categorized into three categories: the civil courts, the criminal courts, the revenue courts. As the name suggests, the civil courts will be looking to the cases related to the civil matters. The criminal court will be looking into the matters relating to the criminals or crimes. The revenue court will be dealing with the matters relating to the revenue or tax authorities, taxation authority or tax related matters. Civil court, the district judge or the district and session judge function through sub-judge family court, municipal court, and then we have small cases court. As far as the criminal courts are concerned, the session judge or district and session judges that presides over the cases. Metropolitan magistrate, class 1, class 2 and class 3 magistrate are there to take into these cases. Revenue courts, the board of revenue is there, the commissioner or collector who deals with the taxation, taxing authority or taxation authority, the tehsildar and naib tehsildar. These are all the functionaries in a hierarchical structure which looks into the matters which are brought to them in relation to the different three types of cases. Civil courts. The court of the district judge is the highest civil court in a district to deal with civil cases. Very often the same court is called the court of district and session judge. When it deals with both civil and criminal cases at district level, the judge of this court is appointed by the governor of the state. Below the court of the district judge, there may be one or more courts of sub-judges in the district. Separate family courts which are equal to the court of sub-judge or subordinate judge have been established in district to exclusively hear cases of family dispute like divorce, custody of children, etc. Below them there are court of munsifs and small cases court which decide the cases involving petty amounts. Now, petty amounts here means the cases pertaining to less than 2,000 rupees, 5,000 rupees according to their financial penalty. No appeal can be made against the decisions of the small cases court. Any kind of penalty imposed has to be paid. All these courts hear and settle civil disputes. As the name goes, civil courts will be looking into all kinds of civil cases. The court of district judge, called the district court, hears not only appeals against the decisions of the courts of subordinate or sub-judges, but also some of the cases being directly in the court of district judge itself. Appeals against these decisions of this court may be heard by the High Court of that state where the case has been registered. Civil courts deals with the cases pertaining to the disputes between two or more persons regarding property, divorce, contract and breach of agreement or landlord and tenant dispute. As far as we have gone through this civil court case theory, we have just gone through to an extent we are now able to understand what kind of cases will be dealt under the civil court. Next we have the criminal court. The court of the session judge, known as sessions court, is the highest court for criminal cases in a district. Below this court, there are court of magistrates of first, second and third class, as we had discussed in the flow chart. In metropolitan cities like Delhi, Calcutta or we can say Kolkata, Mumbai, Chennai. First class magistrates are called metropolitan magistrates. It is to be understood for the competitive exam as far as who are known as the metropolitan magistrates. So in metropolitan cities like Delhi, Calcutta, Mumbai and Chennai, the first class magistrates are known as metropolitan magistrates. All these criminal courts are contempt to try the accused and to award punishment. That means to a extent they have the power to punish the culprit as sanctioned by law in accordance with the laid down provisions of the law to those who are found guilty of violation of law. And definitely, as far as the constitutional bindings are concerned, we have to catch hold of the culprit. Criminal courts hear criminal cases which are related to violation of laws. These cases involve theft, dacoity, rape, arson, pickpocketing, physical assault, murder, etc. Now, the types and the nature of cases is to an extent is now clear, which the civil court will be dealing with. In such cases, the guilty person is awarded punishment. Always it is to be done. It may be fine, imprisonment, or even death sentence. And where the death sentence is given by them, the party to the case has the right to approach to the higher court, and that is the High Court of the state, and then the matter may be continue as per the judicial procedure is concerned. Normally, every accused is presented by the police before the magistrate. The magistrate can finally dispose of cases of minor crime, but when a magistrate finds prima facie of serious crime, she may commit the accused to the session court. Thus, session court try the accused who are sent up to them by the magistrate concerned. As mentioned above, an accused who is awarded death sentence by the session court can be hanged to death only after the sentence is confirmed by the High Court. Otherwise, our constitution also provide a way that the person can appeal in the Supreme Court also. Revenue courts, the last section. The revenue courts deals with the cases of land revenue in the state. The highest revenue court in the district is the Board of Revenue. This is an important point to be understood for all. Under it are the courts of commissioners, collectors, tehsildars and assistant tehsildars. The Board of Revenue hears the final appeals against the lower revenue courts under it, looking into any kind of financial manipulation has been done, corruption has been done, whatever has been brought, what knowledge has been brought to their knowledge. Appointment of judges as per Article 233. The appointments and promotion of the judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. A person not already in service of union or the state shall only be eligible to be appointed a district judge if he has been for not more than 7 years an advocate or pleader and is recommended by the High Court for appointment. Control over subordinate courts is a collective and individual responsibility of the High Court, as it is the head of the judiciary in the state and has got administrative control over the subordinate courts in respect of certain matters. And finally, we end our lecture today. Thank you for listening. Thanks you all.